with British Petroleum on charges related to an oil refinery explosion, violations of the Clean Air and Water Acts, and allegations of price manipulation. $50 million of the fine was for charges arising from an explosion in 2005 in Texas City, Texas, the first criminal prosecution under the Clean Air Act. This is about half an hour.
Assistant Attorney General Alice Fisher of the Department's Criminal Division, Acting Assistant Attorney General Ron Tempest of the Department's Environment and Natural Resources Division, Kenneth Jones, Deputy Chief Inspector of the U.S. Postal Inspection Service, Krista Edwards, Acting Administrator for the Pipeline and Hazardous Materials Safety Administration of the Department of Transportation, Gregory Mosek, Director of Enforcement for the CFTC, and Ken Kaiser, Assistant Director of the FBI's Criminal Investigative Division. Today, we are making several announcements related to the energy company BP, which has agreed to pay the United States government approximately $370 million in fines and restitution relating to a series of criminal matters. 2 involve fraud, and 2 are environmental crimes. Taken together, these actions demonstrate our substantial commitment to enforcing the nation's laws for the protection of our environment and the integrity of our markets. First, the Department of Justice will file a plea agreement with BP Products North America, Inc., resolving charges stemming from a catastrophic explosion at the company's Texas City Refinery on March 23, 2005, in which 15 workers were killed and more than 170 were injured. Under the agreement, the company will plead guilty to a 1-count information charging it with a felony violation of the Clean Air Act. BP will pay a criminal fine of $50 million and will serve a 3-year period of probation. This is the largest fine ever assessed to a single entity under the Clean Air Act, and this is the first criminal prosecution under a section of the Act specifically created to prevent accidental releases that result in death or serious injury. An investigation revealed that the explosion was caused by improperly released vapor and liquid, and that several procedures required by the Clean Air Act to reduce the possibility of just such an explosion were either not followed or had not been established in the first place. Second, BP Exploration Alaska Incorporated has agreed to plead guilty to a violation of the Clean Water Act to resolve its criminal liability relating to pipeline leaks of crude oil in Alaska. As part of the guilty plea, BP has agreed to pay a $12 million criminal fine, $4 million in community service payments to the National Fish and Wildlife Foundation, and $4 million in criminal restitution to the state of Alaska. The company has also agreed to 3 years of probation. This investigation involved 2 different leaks from oil transit lines operated by BP in March and August of 2006. Both leaks were the result of BP's failure to heed many red flags and warning signs of imminent internal corrosion in the lines. The tragic explosion at the Texas City Refinery and the pipeline leaks in Alaska were sad reminders that our environmental laws exist both to protect the lives and safety of the public and also to preserve our natural resources. Businesses that ignore those laws and endanger their workers and communities must be held accountable. Today's announcement shows that they will be. In a third case, the Department filed a criminal information in the Northern District of Illinois, charging BP America Incorporated with 1 count of conspiring to violate the Commodity Exchange Act, mail fraud, and wire fraud. The charges relate to an alleged scheme to manipulate the price of propane. Under the terms of a deferred prosecution agreement, the government will defer prosecution for 3 years, and the company will cooperate with an independent monitor and department investigations. The company will also pay a criminal penalty of $100 million, a civil penalty of $125 million, restitution of $53 million, and a payment of $25 million to the U.S. Postal Inspection Service's Consumer Fraud Fund. And finally, earlier today, a grand jury returned a 20-count criminal indictment charging 4 former employees of BP America for their part in the alleged conspiracy to manipulate propane pipe prices and to corner the market. According to the indictment, the scheme resulted in artificially inflated propane prices in February and March of 2004. Of course, an indictment only sets forth charges, and all defendants are considered innocent until proven guilty in a court of law. The integrity of the marketplace is crucial to our country's economy, and our laws recognize the importance of commodities like fuel and the hardships imposed on consumers by improperly inflated prices. The Department of Justice is committed to supporting fair dealings in the marketplace through the application of these laws. I would like to commend the excellent work and the coordination on these cases by the United States Attorney's offices for the Southern District of Texas and Alaska, and the Department's Criminal and Environmental and Natural Resources divisions. In addition, today's announcements demonstrate the success of the Department's cooperation on both criminal and civil matters with our investigative partners at the FBI, the Department of Transportation, the U.S. Postal Service, EPA, and the CFTC. And now I'll turn the microphone over to Walter Lucan, who will give you more details about the CFTC's part of today's settlement.
Thank you, Mr. Attorney General, for your comments. Good afternoon, ladies and gentlemen. I'm Walter Lucan, Acting Chairman of the Commodity Futures Trading Commission. Today marks the conclusion of a significant enforcement action by the Commodity Futures Trading Commission, the U.S. Department of Justice, and the U.S. government. For those of you who are not familiar with the CFTC, we are a small but highly specialized federal agency that polices the integrity of the nation's commodities markets. The CFTC's mission is to protect the markets and the public from fraud, manipulation, and abusive practices. We strive to encourage open, competitive, and financially sound commodity markets, and when natural forces of supply and demand are intentionally disrupted by illegal activity, we aggressively pursue those who have caused the disruption. During the last 5 years, the CFTC has filed 64 cases against corporate entities and traders for a number of violations in the energy sector. Those cases included charges of manipulation, attempted manipulation, false reporting, and wash trading. Although energy futures markets are only one part of our portfolio, they play a fundamental role in America's everyday lives, determining the prices we pay for gas, propane, and other energy products. We accordingly devote significant resources to pursue those that manipulate the energy markets. Today's manipulation settlement marks the largest in the CFTC's history. BP and its traders cornered the propane market that serves as a primary source of propane in the Northeast and Midwest regions of the United States. The $53 million restitution amount paid today is intended to be returned to the victims of the company's abuse. As indicated in our lawsuit, the BP traders were actually caught on tape discussing how their trading activity would determine whether BP could, quote, control the market at will. It is our hope that this U.S. government settlement, which totals $303 million, sends a clear message to others that manipulating a commodity market has serious consequences. We filed this case against BP a little more than a year ago in federal court in Chicago, Illinois. From that point of time, we have worked closely and collaboratively with the Department of Justice to obtain a favorable result in this matter. We've obtained a significant settlement, which includes the appointment of an independent monitor to provide ongoing oversight of BP's compliance functions. This settlement should succeed in continuing to improve BP's corporate culture and help ensure that such activity does not occur again in the future. In closing, I want to compliment the Department of Justice on the fine work of the dedicated staff, including Stacy Luck, Jared Duffy, Paul Pelletier, Jay McMahon, Stephen Tyrell, and Assistant Attorney General Alice Fisher. I also want to thank personally our enforcement staff at the CFTC, Director Mossick, Deputy Director Joan Manley, Associate Director Paul Hayek, Senior Trial Attorneys Joe Kazaneski and Judy Lee, and Senior Investigator Charlotte Ullmeyer for their long hours and hard work on bringing this case. Thank you very much, and I'll turn it over now to Grant with the EPA.
Well, thank you, Chairman Lucan. I want to thank Acting Attorney General Peter Keisler for arranging this press conference announcing BP's decision to plead guilty to separate criminal violations of the Clean Air Act in Texas and the Clean Water Act in Alaska. BP committed serious environmental crimes in our two largest states. Every entity that is subject to environmental laws has an obligation to comply, but global companies like BP, with their experience, technical capabilities, and financial resources, have no excuse for committing environmental crimes. The situation in Texas City is especially tragic, involving the death of 15 people and the injury to over 170 others. The law that BP violated, requirements related to the prevention of accidental releases of air toxics and extremely hazardous substances, was enacted after the catastrophe in Bhopal, India, that killed thousands in 1984. It is critical in safeguarding workers as well as the public that facilities subject to these requirements have procedures in place to avoid explosions like the one that occurred at BP's refinery. EPA will continue to enforce these vital Clean Air Act provisions. BP's oil discharge on the North Slope, for which the company is pleading guilty today, should not have happened. The company disregarded many warnings which should have led them to fix or replace their corroded transit pipelines before they leaked over 200,000 gallons of crude oil into one of the nation's most sensitive ecosystems. In addition to the fines and restitution, the plea also requires the company to provide funds to the National Fish and Wildlife Foundation to support the Arctic environment in Alaska, and also has provisions that address the miles of corroded pipe. EPA will continue to aggressively pursue Clean Water Act violations that threaten our nation's sensitive ecosystems. BP must take a long, hard look at its decisions, actions, and omissions that led to today's guilty pleas and take action to ensure that they never occur again. In closing, I'd like to acknowledge the efforts of those concerned citizens and oil industry workers who provided critical information to the authorities during the investigation. And now I'll turn it back to the Attorney General.
Thank you, Grant. The 9 of us are now available to answer any of your questions. Yes, sir.
$50 million fine. Ian Talley from Dow Jones Newswire. $50 million fine for the Texas City. In light of 2005 profits for BP, I think it was something like $22 billion, and BP has set aside $1.6 billion to deal with Texas City. Is $50 million really enough to deter something like this again, where 15 people died, 170 were injured, and isn't that really just a slap on the wrist?
Ron, would you like to take that?
Before you speak, I appreciate it.
Ron Tempest, I'm the Acting Assistant Attorney General in the Environment Division. I think it's important in addressing that to understand $50 million addresses what we think was serious criminal conduct, and big or small, $50 million is a real number. It's enough to catch any corporation's attention. It's the largest criminal Clean Air Act criminal fine ever imposed. In connection with the other aspect of your question, there are other avenues for the victims who have been pursuing civil lawsuits or otherwise seeking civil settlements with BP, and BP's own reporting on that indicates that they've paid $1.6 billion or thereabouts at this point to resolve those. So I think you have to understand the $50 million in that context. The $50 million is addressed solely to the criminal conduct. There are other proceedings that BP is engaged in with the victims that are resulting in additional payouts that at this point BP has announced are about $1.6 billion.
And the only thing I would add to that is that BP is also now required to comply with conditions that are being imposed by the Texas Commission on Environmental Quality and by OSHA in order to help make sure something like this doesn't happen again. Yes, sir.
How do you allocate the $53 million in restitution in the propane case? Does it go to consumers, or is it more market participants?
It goes to a fund which is going to be administered by a third party. The victims who are going to be entitled to obtain money from that fund are identified in the deferred prosecution agreement. They are the purchasers of the propane who paid the artificially inflated prices that the scheme involved.
So they're retail consumers.
No, they are the direct purchasers of, they're the direct purchasers who then might have resold it to others, but it's only the direct purchasers who are going to be recovering money from the fund at this point. As the investigation continues, insofar as we find that there are other people who suffered economic injury from the scheme, there may be a way also to ensure that they get money as well, but that remains to be seen.
Homeowner or whatever.
Right, we're not talking about homeowners. This is the purchasers who paid the prices.
Do you know how many of them, or do you have any names? Are there any big corporations or energy suppliers?
I'm not sure. Does anyone else on the... We'll try to get that information to you. Yes, sir.
Does this, Joe Kamalik with ISIS News, a question for Mr. Grant or whoever else may care to answer, does this mean that the EPA or the government will seek criminal charges in any subsequent release of a hazardous substance that results in a fatality, and might the government seek criminal charges against companies, individuals in the companies who are responsible for those emissions that result in fatality?
Well, I think rather than respond to hypothetical, I would look to this case and say, here was a case where the company's pleading guilty to a criminal charge, a felony, based on their ignoring many, many signs and taking the steps that would be required to ensure a safe workplace. Obviously, any case in the future, we'll have to look at it on a case-by-case basis. But here you had a failure to follow procedures, you had clear warnings, and unfortunately had a very grave tragedy.
Let me ask the same question a different way. I'm with the Associated Press. Is this investigation against BP over, or might there be some kind of criminal charges or other charges against individuals of the company in the future?
I think I'll let the Department of Justice answer that one.
The investigation's ongoing. Part of the deferred prosecution agreement requires BP to cooperate with that investigation. I'm obviously not going to comment today on whether charges might be brought against other individuals in the future, except to say that nothing we've done today forecloses that.
Teresa Morgan, Inside OSHA. So does that mean that the Department of Justice will continue to investigate occupational safety and health violations as opposed to environmental?
I'm sorry, I was referring to the deferred prosecution agreement in the pricing matter, and that's where there's going to be an ongoing investigation in which, and I'm not sure, maybe the AP was referring to a different...
Just everything.
Everything.
So in the Texas case, the investigation's over.
Is that correct?
Similar to the circumstance in the commodities case, the agreement, the separate agreement that they've entered into as to this Texas City case calls for the company to continue to cooperate with the investigation. We will, as we go forward, we will make decisions as appropriate as to any further charges.
Tina Seeley with Bloomberg. Can you identify the people that were charged and what sort of sentences they could face?
In terms of the names, I'll give you the sentences first, maybe someone can get me the names. You have conspiracy counts where the statutory maximum would be 5 years and $250,000 fine. You have the substantive Commodity Exchange Act counts where the statutory maximum is 5 years and I think a $500,000 fine. The fraud counts each would carry a statutory maximum of 20 years. And in terms of the names of the people, Mark David Radley, James Warren Summers, Cody Dean Claiborne, and Carrie Keenan-Brugger.
On the tapes that have been previously released, those individuals, and I think Mr. Dennis Abbott, who's pleaded guilty, they sound almost gleeful and happy about their efforts to manipulate the markets and control the markets. I'm just wondering if anyone on the stage has reaction to what their feeling was when they first heard their glee and happiness about this.
I'll invite Alice or Walter.
Certainly, our feelings were outrage that these people were taking advantage of innocent consumers potentially and manipulating the markets. That's why we aggressively pursued them from our point of view and brought in the cooperative help of the U.S. Department of Justice to bring in criminal action. And this is the result today, is making sure that justice is brought to bear.
Do you have any idea of how many consumers might have been impacted by the price fixing?
We do have numbers. Let me turn it over to, it's significant. People who use propane in their homes to heat their homes in the winter, it's something to the order of about 7 million customers, I believe, that use propane. But let me turn it over to Greg.
The way the market is structured, propane obviously ran along the pipeline that's discussed in the complaint. Depending upon whether people lifted propane off of the pipeline or didn't lift off the pipeline during the relevant time period and who lifted off of the pipeline and whether they bought that propane and then resold it at inflated prices is all currently going to play out in terms of how the restitution fund will be structured. So as we sit here today, there's a lot more work that needs to be done by the person that administrates that fund to figure out exactly who the victims were according to the plan as laid out in the documents that were filed today.
That 7 million number,
That's
what is
people, there's millions of people who obviously use propane to heat their homes up and down the East Coast. I can't stand here today and tell you exactly who was affected out of those 7 million people. There could have been people affected. There may not have been people affected. It depends on how prices were passed on to them from the middlemen to the ultimate consumer.
It's fair to say that potentially 7 million people, and most of these are in the Northeast, were potentially affected?
There was an impact. Obviously, the expert economists who came up with the number for us, the consulting firm of 53 million and some change, made a determination that that was a market impact. I can't specifically say who was impacted at this point in time, it would be premature.
So 53 million is the market impact.
That's correct.
Yes.
Just wondering, on the CFTC, on the deferred prosecution agreement, will there be specific executives that are stripped out of that deferred prosecution agreement, or have there already been executives or people who are stripped out of that agreement? And the second question is whether a monitor has already been identified.
Monitor has not been identified, and when we identify the monitor, we'll need to get the court's approval for that. But that process is ongoing, and I think we're pretty close on that one. I don't believe that there are any executives who were stripped out as part of the deferred prosecution agreement, but obviously the 4 individuals whose indictments we announced today are all former executives of BP.
Right. The investigation will continue. The company will cooperate on the ongoing investigation, but the deferred prosecution agreement itself does not give a pass to any individuals.
Yes.
Steve Cook with BNA. What are the implications for BP for pleading guilty to a felony as opposed to a civil agreement that could have involved the same amount of fine?
Well, from our perspective, of course, we sought the felony conviction because we thought it was the appropriate response to the seriousness of the event. In terms of the consequences for BP, Alice, would you like to address that?
For the deferred
Why don't you get up to the microphone?
Yeah, so I think you're probably talking about the environmental felony plea, so that could be Ron. I'm gonna pass it on
I'm sorry,
to Ron. That's okay. I won't tell you.
And I, in turn, am going to pass you back to BP. I mean, ultimately, it's for them to evaluate what consequences a plea to a felony, a plea to a misdemeanor may have to them or to their business model. That is not something that we weigh heavily in our own assessment of what's the appropriate disposition.
Are there any ongoing sort of obstacles for them because of this felony conviction? Are they under some sort of probation that they have to comply with any kind of restrictions or anything like that?
Let me say 2 things about that. Each of the plea agreements, because these are 3 separate agreements, one will be entered in Alaska, one in Texas, and one in Chicago, but the agreements in Alaska and Texas both contemplate BP's agreement that they will be put on a term of 3 years probation. In connection with that period of probation, in each place there are either requirements for them to, as part of that probation, carry out things they've already agreed to do with the Texas Commission on Environmental Quality and with OSHA. That will become part of the order of the court, so that if they fail to do those, they will be in violation in terms of probation. In Alaska, the agreement contemplates that they will be doing various things related to the pipeline and to the improvement of the pipeline. If they do those more quickly, there is the possibility of them being relieved from probation earlier than the 3 years. So there's a kind of firm incentives there for them to work with the Department of Transportation, Alaska officials, EPA, in terms of getting the pipeline operations where they need to be. It might be appropriate for Krista to speak a little bit to what Department of Transportation has already been doing with respect to the pipeline as well, because there have been steps taken even before this agreement was reached today.
Krista Edwards with Pipelines and Hazardous Materials Safety Administration. Today's resolution does not change at all the existing corrective action order that's in place that governs BP's North Slope pipeline operations, and that was put in place immediately after the spill in March of 2006. It imposes very rigorous, extensive requirements related to the maintenance, the pigging, the assessment, monitoring of the pipelines as they are as BP, and contemplates that BP will, as the BP is committed to do, replace the transit lines up there with new pipelines, and we are continuing our oversight. We've been involved in oversight since the spill was first discovered, and today's resolution does not change the path forward in terms of our oversight.
Can we be clear on one thing? The continuing investigation relates only to the trading aspect of the case, not to Texas and the Alaska settlements, or is it all?
No, we will continue to look at everything there is to look at, and we're not foreclosing anything that might come out of those investigations. Yes, sir.
Previously, you all have treated this as separate items, but now you're bringing this all together in one big hit out of the ballpark. What does that say about the view of BP's systemic problem as a corporate cultural problem? And would you say that they have addressed that? Have you noticed any changes in terms of cooperation since Tony Hayward came in? Can you just talk about that systemic problem or not?
Well, in terms of the fact that these are all being announced together, they all reached state of maturity at about the same time, and it's not uncommon for a defendant or a potential defendant to want to resolve a whole set of matters, in one step. In terms of systemic problems, I mean, I don't think I can generalize too much from these individual matters. With respect to each of them, there were very serious problems that these resolutions address. They are addressed now both in terms of the penalties that are being exacted and in terms of the sort of corrective actions and requirements that are being imposed on the company going forward. Obviously, the appointment of a monitor in the pricing case and the actions of the state and federal regulators in the environmental cases are there because we're not simply confident that that without that kind of intervention, we'll be happy the way things are going forward. So all of these are steps that we're taking to try to ensure that their compliance record improves going forward.
The fact that there are these major fines, the largest settlement fines that you've seen from several different agencies, for the same company in a very short period of time, as saying anything about the corporate culture of BP?
I don't want to make broad generalizations. Obviously, the actions that we're responding to today reflect that there were some very serious problems within that company.
Okay, and since Tony Hayward has taken over, has there been any sort of change in the cooperativeness of the company?
I'm not in a position to comment on that.
Take two more questions.
Who will be in charge of monitoring BP over the next 3 years in Texas City in terms of making sure they don't violate the probation? Is that DOJ or OSHA or Texas Commission?
Well, DOJ, but we'll obviously be consulting with our partners in the federal government and at the state level as well.
What will that monitoring look like?
I'm not sure I know what, I mean, we will be receiving information and consulting with the regulators to make sure that they are complying with the requirements.
One last question.
So is part of the reason that this whole thing is happening today because BP wants it that way? You said
No, this has nothing to do with what BP wants.
You said before defendants want to sometimes bring things.
I was just explaining the coincidence of timing that we have several resolutions of three matters which are really quite discrete. Obviously, the deferred prosecution agreement and the indictments we're announcing today are related. The other matters aren't related except for the fact that they relate to the same company. And I thought to some extent the question was, gee, you're resolving all these things at once, and I simply wanted to point out that it's not uncommon when a company has a bunch of different matters before the government for it to want to try to resolve it globally and for us to do that if each of the matters is being resolved appropriately.
Just, can you clarify
Thank you very much.
can you just clarify just one small thing about the further investigations?